European Convention on Human Rights. Here we go. 1. Regional instruments. A. European Convention on Human Rights, ECHR, Introduction. The European Convention on Human Rights, ECHR, stands as one of the most influential regional human rights instruments in the world. Born from the ashes of World War II and inspired by the ideals of liberty, democracy, and rule of law, the convention was created to protect individual rights and prevent the recurrence of atrocities that plagued Europe in the first half of the 20th century. Drafted under the auspices of the Council of Europe, the ECHR laid the foundation for a comprehensive and enforceable regional human rights regime, leading to the establishment of the European Court of Human Rights, ECTHR. This section delves into the historical background, structure, substantive rights, enforcement mechanisms, landmark judgments, criticisms, and the evolving relevance of the ECHR. Historical background. Context of creation. Following the devastation of World War II, European nations sought to ensure that the human rights abuses committed during the war would never be repeated. The ideological influence of the Universal Declaration of Human Rights, 1948, and the desire to strengthen democratic governance provided a strong impetus for regional cooperation. The Council of Europe was founded in 1949 with the primary aim of promoting human rights, democracy, and the rule of law. Within a year, member states agreed upon the necessity of drafting a binding treaty to safeguard fundamental freedoms. This effort culminated in the signing of the ECHR in Rome on 4 November 1950. It entered into force on 3 September 1953. Significance. The ECHR became the first instrument to make human rights enforceable through a judicial mechanism. It pioneered an approach where individuals, and not just states, could lodge complaints about human rights violations. Structure and content of the ECHR. The convention is a relatively concise document comprising a preamble, sections, and articles. It has undergone multiple amendments, most notably through protocols that have expanded and clarified the rights protected. Core Sections 1. Substantive Rights, Articles 2 to 18. These articles lay out the fundamental rights and freedoms. 2. Procedural and Institutional Provisions, Articles 19 to 59. These define the mechanisms for enforcement and supervision, including the role of the European Court of Human Rights. 3. Protocols. Several protocols, such as Protocol No. 1, Protocol No. 6, Protocol No. 13, have added rights like the abolition of the death penalty and protections concerning property and education. Rights protected under the ECHR. The ECHR primarily guarantees civil and political rights. Some of the most significant rights include right to life, Article 2, Prohibition of torture, Article 3, Prohibition of slavery and forced labor, Article 4, Right to liberty and security, Article 5, Right to a fair trial, Article 6, No punishment without law, Article 7, Right to respect for private and family life, Article 8, Freedom of thought, conscience and religion, Article 9, Freedom of expression, Article 10, Freedom of assembly and association, Article 11, Right to marry, Article 12, Right to an effective remedy, Article 13, Prohibition of discrimination, Article 14. These rights are not absolute. Many are subject to limitations in the interests of national security, public safety, the protection of health and morals, and the rights and freedoms of others, but such limitations must be lawful, necessary, and proportionate. The European Court of Human Rights, ECTHR, Establishment. Established under Article 19 of the Convention, the ECTHR is seated in Strasbourg, France. It began operation in 1959. Structure. The court is composed of one judge from each member state of the Council of Europe, currently 46 judges, although judges act independently and do not represent their country. The court operates in committees, chambers, and a grand chamber. Committees, 3 judges, handle clearly inadmissible cases. Chambers, 7 judges, deal with complex cases. Grand Chamber, 17 judges, handles cases raising serious questions of interpretation or involving conflicting judgments. Jurisdiction and functions. The court adjudicates individual applications, Article 34, any person, group, or NGO can bring a claim alleging a violation. Interstate applications, Article 33, states can bring cases against other states. The court's judgments are binding on states, and compliance is supervised by the Committee of Ministers of the Council of Europe. Important protocols. The convention has been amended and supplemented by numerous protocols. Some major ones include Protocol number 1. Protection of property, right to education, right to free elections. Protocol number 6 and number 13. Abolition of the death penalty. Protocol number 11. Fundamental reform of the court structure to allow direct access by individuals. Protocol number 14. Streamlining the filtering of applications to reduce the backlog of cases. Landmark cases and jurisprudence 1. Handyside vs. United Kingdom, 1976. The court stressed the importance of freedom of expression, even for ideas that offend, shock, or disturb. 2. Soaring vs. United Kingdom, 1989. The court ruled that extraditing a person to a country where they face inhuman or degrading treatment would violate Article 3. 3. Öcalan vs. Turkey, 2005. The case involved the Kurdish leader Abdullah Öcalan and centered on fair trial rights and the death penalty. 4. Dudgeon vs. United Kingdom, 1981. The court found that laws criminalizing homosexual acts between consenting adults violated Article 8, right to private life. 5. Hurst vs. United Kingdom, 2005. The court ruled that a blanket ban on prisoner voting violated Article 3 of Protocol number 1. Impact on member states. The ECHR has had a profound impact on domestic legal systems across Europe. Incorporation into national law. For example, the Human Rights Act 1998 in the UK incorporates ECHR rights into domestic law. Influence on constitutional courts. Countries like Germany, Italy, and France have aligned their constitutional interpretation with Strasbourg jurisprudence. Political influence. Membership of the Council of Europe and adherence to ECHR principles are essential for European Union accession. Criticisms and challenges. Despite its successes, the ECHR and ECTHR face several criticisms. Backlog of cases. The court often faces a huge caseload, leading to delays. Perceived overreach. Some states argue that the court interferes excessively in national sovereignty. Compliance issues. Some judgments are not promptly or fully executed, e.g., against Russia, Turkey. Politicization. Some criticize the court for making politically sensitive rulings. The court has addressed many of these criticisms through reforms like Protocols 14 and 15, aimed at making the court more efficient. Conclusion. The European Convention on Human Rights is a cornerstone of human rights protection in Europe. Through its comprehensive rights catalog and robust enforcement mechanisms, it has empowered individuals, strengthened democracies, and raised human rights standards. While facing modern challenges, especially in balancing sovereignty with supranational judicial review, the ECHR continues to serve as a model for regional human rights systems globally. Its spirit, that human rights must be protected, justiciable, and accessible, remains as relevant today as it was in the post-war years when it was first conceived. Thank you for watching. Please like, share, and subscribe the channel.